Hello, everybody. This is Jamie Upson from Stonehearth Capital Management. Thank you again for joining us for our July 31st presentation on the ABCs of trusts. Just a reminder that this subject matter that we're talking about today was chosen by our clients. What we do is we look to get a sense from our clients. We ask questions of what they would like to learn more about, and this was a pretty popular topic. So popular that this is actually our highest attended webinar to date, which is really exciting for us in particular. Just some housekeeping on the control panel for the go-to meeting or the webinar. There should be a section where you can ask questions. Go ahead and submit those questions, any that you have, and what we'll do is we'll address those at the end. Amanda will jump on the line and she'll read the questions to us. And if we don't have time at the end to address any of them, then what I'll do is I'll just reach out to the individual that asked that question. So let's kick off. Here we go. So hopefully everybody can see, and I'll shut off my video here. Hopefully everybody can see the ABCs of trusts and should you have one. So where I want to begin is what we'll address today is, first of all, what is a trust? Let's define that and get a sense of what it is first before we start determining whether we need one or not. We want to address why someone creates a trust. A pretty popular question is, what's the difference between irrevocable trusts and revocable trusts? When should you have a trust, which is the core point of this discussion. We're going to highlight estate taxes as a popular reason for why people should have trust, or certain people in certain circumstances should have trust for estate taxes. And then finally, when should you pass on creating a trust? A trust is not for everybody. So I'm going to highlight some of those timeframes where I think it makes sense to pass on establishing a trust. So first, let's focus on, well, what is a trust? This is right from Investopedia. Trust is an agreement that describes how assets will be managed and held for the benefit of another person. There are three parties in this relationship of establishing a trust, and I liked this image, so we put this on here with the help of Amanda. You've got the trust, the creator. They, like most things in the legal field, they create multiple words that have the same definition. So what we call a creator of a trust, they also call a settler, a grantor, or a trustor. That is this gentleman right here. They're the person that is creating the trust agreement, which is here. They assign a trustee, who's the person that's responsible for managing the assets that are in the trust for a beneficiary. And just note, while we're showing you a person here, the trustee does not have to be a person. It can be an organization or corporation. For example, through TD Ameritrade, which is where our clients custody their assets, we have access to professional trustees, or what they also call corporate trustees, that will step in, and that's all they do for a living, is they act as trustee for trust accounts. So the trust, the grantor, the creator, the settler, the trustor, all the same person here, they put assets into the trust after they create the trust document, and they assign a trustee to manage these assets, whatever's in that trust, and they manage it ultimately for Junior down here, who we'll call the beneficiary. Many times, this person who creates the trust assigns themselves as the trustee, and also at least the first or primary beneficiary of whatever they put into this trust. And there can be multiple layers of beneficiaries here. So you have the first primary beneficiary, which many times is either somebody that can collect the income that the trust assets generate. And then many times they describe the remainder beneficiaries as the people that get the principal, the money that's in the trust, after the person that was getting the income passes away. We'll go through a couple of details, but just remember that there are three players here, and in many situations, most situations, they're actually the three roles are fulfilled by the same person. Not always the case, and sometimes it can't be the case, in particular when we talk about irrevocable trusts. But here, when we're talking about revocable trusts, which I'm going to go into in a minute, the typical scenario is that all three of these are the same individual, which we call the creator. So one of the things that is important when you create a trust, which is once you've drafted this document, you got to transfer the assets and put assets into the trust. And that's actually not always that simple. You have to contact the banks. You've got to potentially go see the registry of deeds to change the deed on your property so that you can literally transfer the ownership of that from yourself to the trust. We call that whole process funding the trust. And here where you've got inter vivos, you're just talking about while somebody's alive, living, which is what this actually represents. When somebody's living, we want to go ahead and we want to put money or assets into the trust. Sometimes you create a trust, but you don't put money into it yet. You know, a common one is actually what they call a testamentary trust, where you might even not have even created the trust yet, or you put in a couple of possibilities or preferences into your will, and you say, hey, I'd like to create this trust and I'd like to fund it, but only after I pass away. And that's what they call, instead of inter vivos, you actually have testamentary trusts, which are just that. They're created after somebody passes away. And again, they usually do this through the creator's will, where they designate for the trust to be established and they loosely define the details of that trust. So you can create a trust, you can fund it, sometimes you don't fund it, and sometimes you create the trust after you pass away when you create the trust and fund it. And I know that there's a couple moving parts, but this is the trust world and there are a lot of options. I'm gonna run a poll. I like doing these. Where, let's see here. Let me see if I can find my poll. Here it is. So the poll is the most popular reason to create a trust. What I'd like is if you could just go ahead and select what you think is the most popular reason for creating a trust. Nice, I see answers coming through. Give it about 5 more seconds. We've got a lot of people that have already submitted. Nice, we got most everybody. So I'm going to close the poll, and here you can see that the most popular reason is to avoid probate, and that's actually true. I actually thought a lot more people would select my attorney recommended it, because many times when I ask people, especially new clients, why you created a trust, and many times they'll reference that their attorney had recommended it, but aren't necessarily familiar with the specific nature or the specific question that they had asked the attorney that triggered the recommendation for creating that trust. All of these are
Jamie,
legitimate, probably not because my friend, family, or colleague has one. So the last question on there is probably not the most legitimate one, because really these are personal decisions whether you need a trust or not.
Jamie.
So let's continue on. So the primary reason why you have a trust, the most common one is to avoid probate. And for those that aren't familiar with probate, it just means that when you pass away, if you need to look at your will, or your executor or executrix, who's the person that you have put in charge of settling your estate, if they need to look at your will to identify how you want assets to be distributed, then that is called the probate process, and you need to go through the court systems and hire an attorney, most likely, to help settle and probate your estate. It can be a time-consuming proposition for many estates. They take anywhere from, say, for probate, anywhere from like 9 months to, I've seen, as much as 3 years. So it can take quite a while. And if people want to avoid that process and some of the expenses that are associated with probate, many people will create trusts to help them with that. The second most popular that I find is to identify a backup trustee who can step in to manage the assets in the event that the person that created the trust, who is usually the trustee, becomes ill. So really what you're doing is you're doing this almost the same exact thing that you do with a durable power of attorney. You're assigning somebody to take control and manage that trust in the event that you're unable to for a variety of reasons. And then, as I said, listed because their attorney suggested it, which is a common response that we hear. Oh, we got poll number 2, good. So let's roll out the second one. Do revocable living trusts offer protection from nursing home expenses? Go ahead and answer. I'll fill in some of the blanks here. Revocable living trusts are, I'm going to define in a little bit, and I'm actually going to give you obviously these answers. But revocable living trusts are the type of trust that you can revoke and make changes on versus irrevocable trusts that you cannot. So there's still, we got 76%, 82% of people have voted, nice. So I'm going to close the poll. And we'll find that most people said the answer is no, and that is a true statement. By the way, this is a common concern that I have out there, where I speak to a lot of people that have trusts, and as soon as they say that they have a trust, they are presuming that that means that it's protected from creditors or a nursing home. The answer is, since a revocable living trust is revocable and you can change the terms, you can get access, you could close out the trust, you could terminate it, you could get the money back into your own name. Because of all those rights that the creator or the trustee has, those assets are not protected from a nursing home or creditors. In order to protect assets from creditors and or nursing homes, you really need to be looking at irrevocable trusts. And again, we'll go into more detail about that in a bit. So again, we got 82% of you that voted. We got 64 in the no category, and they are correct. So revocable trusts, as I mentioned, they can be altered, canceled, and they're all dependent upon what the grantor or the creator wants to do. Most times, again, the revocable trust, the creator, the trustee, and the beneficiary are usually one and the same. One thing to note is that after the creator passes away, in most scenarios, it is the creator that is what they're looking for to trigger this. Once that takes place, the trust actually goes from becoming a revocable trust or revocable trust to an irrevocable trust. That is something that's automatic. So while you're living, most of these will be a revocable living trust that you can alter, change, make adjustments to. But then once you pass away, it's sort of locked in, and that becomes when the trust switches from revocable trusts to irrevocable trusts. Just note, and early in my career, I remember being often confused about this. Even if the trust document says revocable on it, it still can now be an irrevocable trust. In most situations, what happened is somebody created a trust, they passed away, and they keep the name of the trust the same. So if it was the Jamie Upson Revocable Trust, when I pass away and it became irrevocable, it might still say the Jamie Upson Revocable Trust. And so just because the name has the word revocable in it, don't assume that it is a revocable trust. When somebody's passed away, most times it becomes an irrevocable trust. So some highlights on revocable trust: they can be modified. I highlighted again, does not offer asset protection from creditors or nursing homes. It is a will substitute. So remember when we talked about probate, if you don't own something jointly, or if you haven't named beneficiaries for assets or accounts, then you have your will, which is sort of a catch-all. It catches everything that you don't own jointly or that you haven't named a beneficiary on. And when you read the will, when you need to read the will to start distributing assets, that is called the probate process. And it is time-consuming. It can be costly, although, I think over the years, the process, at least in Massachusetts, which is our home state, the probate process has become more simplified over the years. It's not quite as complex and time consuming, but no matter what, it almost always takes a minimum of, say, 9 months and usually settles out within a year or two. Only in unusual circumstances does it go on longer. You retain control of the assets in the trust. You are the grantor, trustee, and beneficiary in most scenarios, although it's not required. I could be the grantor and I could list Amanda as the trustee, and I could name my colleague Jenna as the beneficiary. I mean, you can do this a whole bunch of different ways. It's just most times people are doing this to avoid probate as a will substitute, because I'm naming a beneficiary, I don't need to go through the probate process because a beneficiary has already been identified, and that's why I don't have to go through the probate process to look at my will. Income, that let's say that you have a brokerage account that has GE stock in it and it earns dividends. If it's a revocable trust, you get a 1099 at the end of the year from TD Ameritrade showing all of the GE dividends, and that goes right onto your tax return. So you don't need to fill out a separate tax return if you have a revocable trust. And at your death, the trust will have instructions on how to manage and distribute the assets in the trust to the beneficiaries. Sometimes it entails keeping the trust in existence. Sometimes it just involves closing out the trust right away. Let's switch gears over to the irrevocable trusts, which sometimes they're called irrevocable, and I have a tendency to go back and forth between the two. But irrevocable and irrevocable trusts, it's one and the same. When a creator passes away, a revocable living trust automatically becomes irrevocable. Remember, with irrevocable trusts, it is its own separate entity. So it's really no longer associated with its creator. I often think there's a wall between the person that created the trust and the assets that are in that trust when you're dealing with an irrevocable or irrevocable trust. I also like to think of it as just another person, because many times, not always, but many times you'll actually get a tax ID number for that trust, in the same way that we all have social security numbers to identify when we pay taxes who we are. Taxes can be, speaking of taxes can be complex because oftentimes assets in the trust generate income like a savings account. So let's just look at an example and think about this. So if I have money at the bank, let's say that I have $1 million sitting in a whole bunch of CDs and they're earning 3%. 3%, that's $30,000 on $1 million that's in those CDs, and I have to report that $30,000 of interest income. Now, I have a couple of options. I can fill out, because an irrevocable trust is its own separate tax-paying entity. I have to fill out a trust tax return. They call it a 1041 as opposed to a 1040, which is what we all fill out personally. So you fill out a 1041, and in there you report the $30,000 of income that's earned. I'll show you in a little bit that has some hurdles associated with it. So many times people will want to get those taxes paid out to a beneficiary and hopefully reported on that beneficiary's tax return. Again, I've got another poll coming up, so I don't want to give it away, but I'll show you why that's something that a lot of people look to do and why it does add some complexity on this. So just remember that $30,000 sitting in the bank earning $30,000 of interest from those CDs. I have to report it first on the trust, and then I either pay the tax at the trust level, or I take a deduction and I push that $30,000 over to the person that actually received it, and they pick up the tax liability so that the trust would not pick up the tax liability. I know that can be complex. Just remember that they need to file their own tax return and pay their own taxes. And like most things in this field, exceptions do apply, where I've got clients that have irrevocable trusts and they're not filling out a separate tax form, and the beneficiaries, the income beneficiaries, are just putting it right onto their own personal tax return. So again, these can be very complex, and you need to lean on the attorney to find out, based on how they created it, how do the income taxes need to be reported. I think we got poll number 3. Cool. So poll number 3, this one's a pretty good one. So what level of income pushes irrevocable trusts to the highest tax bracket of 39.6%? So just to let people know, for individuals that file an income tax return, only those people that have income at $415,000, only if their income exceeds that amount would that push them into a 39.6 or the highest tax bracket. And for joint tax returns, you got to have $466,000 of income before you hit this highest tax bracket of 39.6. So what do you think the rules are for irrevocable trusts? Go ahead and take a guess. Nice, they're coming in fast and furious. Nice. I'll close the poll, and we've got, let's see here, we've got 8% that said the 12,000 amount. We've got 31 that said 184, 23% said 415,000, and 38%. So the winner of the poll was the highest amount of income at 466. And this is one of those where the 8%, the people that voted $12,401, they're actually correct. So this actually creates a problem for a lot of people that have, or not really a problem, but conundrum, because you've got these trusts that are generating income, and do I pay it out to one of the beneficiaries so that they pick up the tax liability, or do I keep that income, that 30,000 in that example, in the trust so that the trust picks up the tax liability? So here, this is actually from 2016, but I like this guy, Michael Keatsis, and he had a pretty clean report here. So the numbers aren't going to be very different for 2017. But here again are individuals. Here are all the tax brackets. And when an individual has income that exceeds $415,000, we hit the 39.6% tax bracket. For joint married couples, we've got 466 of income. And look at this, trusts. If you have income that exceeds 12,401, then any income above that amount would be taxed at the highest tax bracket. So in our example of $30,000 of income, most of that income is going to be taxed at 40%, which is obviously not good. There are a couple reasons, and I think I have them in here. No, I don't. I did do a white paper, so I have it in the white paper. But one of the reasons that somebody would want to keep the assets, the income, in the trust and not distribute it to one of the beneficiaries, sort of the classic example that we read about often is, what if the income beneficiary is not financially responsible? What if they have a drug addiction or a gambling addiction? You certainly, I'd gladly pay 40% in tax. Oh, I clicked the wrong button. I'd gladly pay 40% tax to not distribute that money to them, so that we could keep the money protected in the trust. And many times, whoever created the trust gives that trustee, the person that it's administering and handling the trust and managing it, the creator usually gives that trustee that discretion so that they can distribute the income to a beneficiary, which is favorable from a tax point of view, because then it would be picked up in this category. But if the trustee feels that it's not appropriate for whatever reason, they can retain the income in the irrevocable trust. And unfortunately, it just means that there'll be a higher tax that's owed. That's actually something that a lot of people don't recognize when they're dealing with irrevocable trusts. And it can be a big surprise for many. Not the end of the year, but the beginning of each year, we send a note to all clients that have an irrevocable trust to just make sure that they know how much money was distributed. The whole reason that we do this is so that they'll remember to tell their accountant that it should be taxed like this on the income, on the personal side, and not at the trust side. When you should consider creating a trust. Number one reason, if you want to avoid probate. That is the most common reason. Another good one, if you want to control assets from the grave. The privacy is a big one, especially in the celebrity world. They want their assets to be private. They don't want people to know who they left money to and in what the details of that arrangement were or are. So for a lot of those people, and I have a trust, and I like the value that it offers from a privacy point of view. Another area that we're always looking for is when people have more than one property in, or have more than one property in more than one state. If that's the case, if you don't utilize trusts, you run the risk of having to probate or open a probate and settle your estate in more than one state. So you just think, when you hear people talk about probate, people sort of cringe. And then if you were to say, oh yeah, by the way, you're going to have to do it twice, I think a lot of people, that might motivate them to do something about it so that they would not have to probate, let alone once, but for sure twice. That they're certainly not going to want to do that. So we have a lot of clients that have homes in Florida and New Hampshire. Those are probably the two most popular areas for at least our clients, that their primary residence is in Massachusetts, but they've got another property up in the Lakes region of New Hampshire, or a winter home down in Florida. That's a perfect scenario where you want to consider creating a trust to hold and own that, at least the second property, so that you don't have to probate in Florida or New Hampshire in those examples. But it might make sense to put both properties into the trust, so you don't even have to probate your primary residence here in Massachusetts as well. If you have a more colorful family dynamic, so if somebody's children from a prior marriage and they remarried, if they want to make sure that their current spouse is taken care of financially, but they don't want to run the risk or are concerned that their current spouse might disinherit their original or their children from a prior marriage, then what you can do is create what they call a QTIP, a qualified terminable interest property trust. Pretty common. There are other reasons to use QTIPs as well, especially here in Mass for estate taxes, but this is a pretty common one where if I pass away and I have children from a prior marriage, but my new spouse, I want to make sure that she's taken care of. If I pass away, I can have the income that's generated. So in that example of the $1 million invested in CDs, that $30,000, I could have that accessible to my spouse so that she can collect that $30,000, but she can't tap into the $1 million. There would be strings attached with that, and it would be harder for her to do that. So that $1 million would be available to be passed on to my children, so that I don't run the risk that my kids would get nothing. Another common reason that people create trusts is they have minor children. This is one of the reasons that I created a trust, or myself and my wife, because we have 2 young children, so that if I passed away, do I want them to receive an inheritance and have access to it at such a young age? Prior to the age of majority, which in most states is either 18 or 21 years of age, the minor's not allowed to manage those assets anyways, so somebody would be appointed to step in. Either it was documented in my will that said I want my brother to manage the assets for my kids if I pass away, or both my wife and I pass away, or the state steps in and they appoint somebody to manage those assets for the minor. But I'll be honest, I mean, my kids are 10 and 12, and I don't know what they're going to be like yet in terms of when they're 18 or 21 years of age. I hope that they'll be responsible, but younger kids are going to make, or younger adults are going to make mistakes that they probably won't make when they're 30 or 35, maybe. So what I can do is, I can put my assets, obviously I'd give them first to my wife, but if she passed away as well, they flow into a trust that's been designed for the minors. A family member's been appointed, my sister in fact has been appointed to manage those assets for my kids until they hit a later age. I don't remember the exact date, maybe mine. Usually I believe I staged it out so they can get some of the money at 25, some of it at 30, and some of it at 35, but I'd have to even look that up. But that's a pretty common scenario. You give it to them in blocks or buckets or percentages. And if they blow the first bucket, at least they have 5 more years to mature, and hopefully they won't blow the second block of funds that you give them. The only way to do this is with the use of trusts, and it's a pretty effective way to be able to protect those assets from children that you're just not sure whether they're going to be financially responsible or not. Another reason to create trusts is estate taxes, and I'm going to talk specifically about Massachusetts. If you happen to live in a state that does not have estate taxes, try saying that 10 times fast, then you don't need to worry about this section, at least the state estate taxes. But here in Massachusetts, we are one of the states that have an estate tax. So if a family, husband and wife, have greater than $1 million, well, then we need to worry about estate taxes, because the state of Mass only gives an individual an estate exemption of $1 million. You can double that to as much as $2 million with the use of estate tax sensitive trusts. So if you incorporate estate tax sensitive trusts as part of your estate plan, you can increase the exemption amount from $1 million to $2 million. If you have $10 million, well, you're still gonna want to increase the exemption amount from 1 million to 2 million, but quite honestly, you're still going to be facing a pretty hefty state estate tax. I like to describe the easiest and fastest way to resolve and get yourself out of this category is to move to a state that doesn't have an estate tax. So move to New Hampshire or Florida. That is one of the reasons why they're pretty popular states. Plus, I always bring up New Hampshire because that's where I grew up, and I've always been very fond of New Hampshire. You got federal estate taxes. So the exemption amount is $5.49 million per person. So if you use estate tax sensitive trusts, you can double this and you can get your exemption for your family up to as much as $11 million. So these are simple tools. Well, I shouldn't say simple. They've been used for many, many years. I believe they started around the 70s when they started using these types of trusts. So they've been tested. We know that they work, and that they're effective at increasing the exemption amount and helping to reduce the amount of estate taxes that you owe in both the state and or federal level. Another reason why you should consider creating a trust is if you have a child that has special needs. What you can do is establish what they call a special needs trust. Assets that are owned, or if you pass away, you can have your assets fund this special needs trust. The beauty of it is that the assets are not considered assets of the child, and if the child's collecting or plans to collect government benefits, you will be able to they'll be able to maintain that eligibility, which is super important. If you just gave the money to Junior and they had a special need and were collecting government benefits, you would make them ineligible. It depends on obviously how much you gave them, but if you instead gave this to them in the form of the special needs trust that they have access to, then they would be able to maintain government benefits. And just so people know, we're going to be sending out a note on it shortly anyways. There are also new accounts called ABLE accounts, A-B-L-E. These are also very useful in these situations if you have a special needs child or children. When you should pass on creating a trust. So if your attorney recommends it to you and you say, you know what, I think there are always pros and cons whenever you're thinking about these things. And here, I think in these scenarios, the cons just sort of outweigh the pros that are illustrated of why you would create a trust. So again, why would you not elect to have a trust. First, if you don't have assets to put into the trust, that kind of makes sense, but it's worth pointing out that it's not appropriate for everybody. A lot of people will benefit from having trust, but one important component to it is that you got to have assets. You don't want to spend the money to create a trust. So trusts, they can range. A revocable living trust, which is the most common, that really the primary reason that people use that is to avoid probate and to appoint somebody to control those assets in the event that they became ill. Those I've seen, $1,500, $2,000, somewhere in that vicinity. As soon as you start incorporating estate tax sensitive trusts, so if you go to an attorney in Massachusetts, or you live in Massachusetts and you see a Massachusetts attorney, and they see that you have greater than $1 million, it's prudent for them to bring up the idea of Massachusetts estate taxes, and they might need to if you have greater than $5 or $6 million, then it makes sense for them also to bring up the federal estate tax situation and identify whether estate tax sensitive trusts would be a valuable addition to your estate plan. Those do cost more, and then you're probably looking at $3,000 to $5,000 to incorporate that. So it's a lot of these are spend money now to hopefully save money later, because if you don't do this and the assets go through probate, well, you could be looking at greater inheritance taxes, and probating assets always has a greater expense or an expense associated with it. And so many times, one of the ways to think about it is if you pay now to create a trust, you're just paying some of those fees in advance. Why wouldn't you want a trust if you're okay if your estate is probated? So I've had some people say, hey, I'm going to be dead. I don't care whether it needs to be probated or not. So that's a personal choice. If privacy is not important to you, if you already have a durable power of attorney, I said that one of the reasons that trusts are powerful, and one of the benefits is if you became incapacitated or ill, and you had a successor trustee, somebody that would step in the event that you couldn't take control of the duties of managing a trust, then you would have a successor trustee that steps in. And that's pretty seamless. It's a nice feature. I was attending an estate planning seminar up in Salisbury, Mass. This was probably about 2 years ago now. And they did talk about the fact that durable power of attorneys are just getting a little bit harder. So let me describe what that is first. So it's a document that most people have as part of a basic estate plan where you appoint somebody to handle your financial affairs in the event that you could not do it. You're still living, but you're incapacitated or ill. Well, durable power of attorney is a document that I need, TD Ameritrade needs, if somebody became incapacitated and somebody, their child or sibling is coming in and saying, hey, my brother, my sister, my father is ill. Here's the document that enables me to make decisions on the account. Now, we haven't had any problems with this. That's actually worked out very well. But when I attended that presentation by a law firm up in Salisbury, Mass, they had said that they're seeing at banks that it's becoming a greater problem and a greater concern, where if I go to the bank, I speak to the teller and I say, look, my father is ill, and here's the document, the legal document that says I can control these assets on my father's behalf and make decisions, they're actually contesting it. And I actually kind of get it, because you can have multiple variations of the durable power of attorney. You could have created one 10 years ago, and then you just decided to update it. How do we know that that's the current power of attorney document? They've had some issues with this, but we've sort of always been able to work through it. And I've just heard that banks are starting to become a little bit tougher to get these through. This is also a law firm that's presenting this and saying that trusts do not experience that same concern. So again, not my experience, nor have I seen any of my clients have trouble at the banks just yet, but I've heard that it's a growing trend, and that's something that we're going to have to pay attention to. And if that does become a concern, it's going to be another reason why we may want to consider, or it's another pro for why you might want to actually create a trust. But for now, I don't see it as a major hurdle, and that's why I list it here as if you already have this, maybe you don't have that need to create a trust where you can name successor trustees. You are not concerned if your estate needs to pay estate taxes. Again, I hear this probably, I don't know, 20, 30% of the time when I talk to somebody that's got over $1 million and I present what the tax exposure is to them or their children in the event that they pass away. And sometimes they say, well, you know what, they'll still get a nice inheritance. I won't be here to write the check. It's not a concern of mine. Or if you don't feel strongly that somebody is going to get money, say you don't have children and maybe you don't have any siblings, you might just say, hey, you know what, I don't care if estate taxes are owed. I'm leaving everything to charity and I'm okay if estate taxes are part of the equation. If you prefer to keep your estate plan simple, using the word trust does add some complexity. Retitling asset, it adds some complexity. There's no way around it. It might be simple for me because I deal with this on a day-to-day basis, but I never forget the fact that for you, it might be the first time that you're dealing with a trust, and that can feel overwhelming at times. Most of your assets are jointly owned or have a listed beneficiary. They call this the poor man's trust, where all you do, if you want to avoid probate, which again is the #1 reason why people create revocable trusts, well, just make sure that everything's owned jointly or list a beneficiary. So even for joint accounts, we list a beneficiary. So it just makes it harder to find ourselves in a situation where there are no beneficiaries listed, when we have to go through the will to identify, well, what's left? What were their final wishes if their children, their spouse isn't living, and neither is their children, and neither are their siblings. So there's you can do your best to try to list a whole bunch of beneficiaries or own everything jointly to try to avoid probate. It is a little bit harder when you're dealing with real estate, because real estate you're not allowed to name beneficiaries on. You can own it jointly, but inevitably if the second person passed away at the same time as you, then that would mean that you have to probate that asset or that real estate. And so the only way that I've found that you can completely insulate yourself from probate is the use of trust, because if you own a home, it's not a sure thing that we can avoid probate. So if you want that sure thing, then you really need to look at the trust. If most of your assets are owned within a retirement account. So if you have $1 million in an IRA account and you don't own a home and you don't have bank accounts, to create a trust doesn't make a whole lot of sense, if it's to avoid probate or to reduce estate taxes. There could be other reasons. Maybe you're leaving the money to minors. So there still could be valid reasons if you have a retirement account. But if it's the primary reasons of avoiding probate, another big one here in Mass is to reduce estate taxes, it doesn't help, because in order to put the money into a trust, you have to withdraw the IRA account. And as many of you may or may not know, when you withdraw money from a retirement account, in particular an IRA, you haven't paid taxes on that money yet, and you need to pay taxes. So you could find yourself very quickly getting into the highest tax bracket, and a lot of those retirement assets would disappear to taxes. That actually concludes this presentation. So I just want to bring you up to speed on what our next presentation is. It's going to be August 30th at 4 p.m. I am giving this one. It's what every beneficiary should know. The following one that my colleague David Giuliano is going to be giving is college planning. So for a lot of you out there that have your children are approaching the time frame where they're getting ready to send their kids to college, or hopefully a couple of years before that point, then you'll want to make sure that you invite them to this college planning presentation that David's doing. David's traveled the country giving presentations on college planning, so I think you'll enjoy a lot of things that he has to say. That's on September 28th at 10 a.m. And then, let's see here, October 19th at 10 a.m., I'm doing estate planning, which, this will tie a lot of things together, where you'll actually hear how trusts work, how asset protection strategies work, all within the realm of estate planning. So at this point, I want to open it up to questions. And again, just as a reminder, if you have a question, just go ahead and type it into the question box on your control panel. I'll turn it over to Amanda.
Hi, Jamie. We do have one question here currently, so please just use the questions box asks, like Jamie said, if you do have a question. The one I have here is basically, what does the probate process entail?
Yep, good point. Or good question. So it's, if somebody passes away, the process typically goes like this. You schedule an appointment with an attorney. The attorney gets an inventory of everything that they owned, because they need everything that was owned so that they can determine whether estate taxes are owed at the federal or the state level. They then submit paperwork to the state of Massachusetts, and this is similar if it's your own state, where they say, look, a probate or an estate has been opened. We are making it public knowledge, because if there's any creditors that are due money from that person that passed away, that you need to give them time to step forward to claim the debt that was owed to them. And that needs to stay open for a certain period of time. Again, during that period of time, you might be filing mass or federal estate tax returns. If your assets are below $1 million, then chances are you're not, and you're just sort of waiting and getting things ready for the ultimate point in time, 9 months, a year later, where your attorney says, okay, it's okay to start distributing the assets according to the terms of the will, which they then submit, which they've already submitted through the state. Usually they say that they're submitting it through the court systems, but that's why there is a probate section of the courts to handle this stuff. So again, with probate, just know that there's costs associated with it, and it can be time consuming to get through it, as opposed to trusts, which have a cost up front, but it's not going to take as much time to settle and start to pay out the assets to the beneficiaries of the trust.
The next question we have is, how does a trust help to avoid inheritance taxes for heirs?
Yep, good question. This is the biggest one. If you want to increase the amount of money that your heirs will receive, if your assets are under $1 million in Massachusetts, then we don't need to worry about the state level. We don't need to worry about the federal level. And so trusts won't be as valuable if your assets are above $1 million. And remember, when I say assets, just pretend that you're cashing in all your chips and paying off all your debts. So if I have a mortgage on $1 million house, I've got a mortgage of $400,000. I've got $600,000 of equity. That goes on to that's part of my estate. It would be the $600,000 figure. Also remember life insurance. This is where, especially younger families, anywhere from 20 to 50 years of age, many times they don't think that they need or would exceed this $1 million. But I'll always ask, well, how much life insurance do you have? Because as soon as they say, well, I have $1 million life insurance, each of us have $1 million life insurance policy, well, then your estate, which includes life insurance proceeds, would be valued at greater than $1 million, and you may want to incorporate estate tax sensitive trusts, which are these right here.
Jamie, how do you pick a trustee?
Yeah, picking a trustee is not that easy. Well, I take that back. Sometimes it is easy. When my wife and I were selecting trustees, we talked about family members, we talked about friends, and we ended up arriving at my sister, who has an economics degree, and I felt like both of my wife and I felt that she was capable, and we trusted her, and we both arrived at the same conclusion. It would have been tougher if we differed on who to select. And you don't always have to select the same person, because you can have your own separate trust, but I think it makes it a lot easier if you do select the same person. I've had not a lot, but I've had maybe 5 to 10 clients that have never been able to pick either beneficiaries or trustees. And so they've really just never gone forward with their estate plan because they've always gotten stuck on who to select, as that trustee is probably the biggest hurdle for not moving forward with their estate plan and putting together trusts. One of the things that I usually suggest, I remind people that because most times we're putting together revocable trusts, you can change the terms. So I think that's a feel-good factor that, hey, don't overly worry it. Yes, we have to be concerned that if you pass away, then yes, that whoever you chose is going to be the trustee, and you may have wanted to change it, or you may have had reservations. You still have time to change that, provided that you don't pass away, and that the trust is still a revocable trust. So what I suggest is put it in place. Get somebody listed there. It may not be, you didn't score that person at 100%, but if they're, at 80%, you feel that the pros outweigh the cons, then go forward with that person. The other thing that you can do, and a consideration, is to hire a corporate trustee, as I referenced earlier. Corporate trustees are just that. They're corporations that do this for a living. Sure, there's fees associated with that. So most times there are fees associated, because if you appoint your attorney to be your trustee, well, the attorney is going to get paid on that. Usually if you appoint your family, sometimes they charge a fee for serving as a trustee. Sometimes they don't. It's all dependent upon the family dynamics and the circumstances. But if you're pretty sure, I would suggest that people go forward with that person that they're agreeing on. That person may not hit all of the marks, but what you could do is name a corporate trustee as successor, so that if that person sort of felt overwhelmed and they needed to step back, it would turn over automatically to a corporate trustee, so that you wouldn't be left high and dry. You'd at least have a backup plan in place, which is why I like to reference the corporate trustees. But I acknowledge that it's easier said than done, selecting a trustee. It's really subjective.
Jamie, do you know what the Mass estate tax rate is, or what the federal estate tax rate is?
Yep. So the state of Mass is all the way from 0 up to 16%. And I feel like people are going to want to shoot the messenger here. But as soon as your assets exceed $1 million, they actually charge the tax rate on your entire estate. So even the first 1 million. And I know that people are like, wait a minute, he didn't say that right. No, I did say it right. It's a weird, quirky rule. So when you cash in all your chips and determine what your estate is valued at, if your estate is $999,999, you check off the box and say, well, nope, my estate is not over $1 million and no estate taxes are owed. If it's $1,001,001, I check off the box that says, yes, my estate is over $1 million, and they charge estate taxes on the full $1,001,001. So, and of course that's going to be at the lower tax bracket, but it's still something to be aware of. I know that frustrates a lot of people, but it is Massachusetts. So the federal, I don't remember exactly, and I think it's right around 40%, but that has changed too. But it obviously ranges from 0. So if you don't have an estate tax owed, and then the max is 40 or 45%, somewhere in that vicinity. I really don't remember the exact number, but a quick Google search should be able to arrive at it.
Jamie, I have a question here that says, our IRA accounts have listed a beneficiary. When figuring our total assets, would these be included?
Yeah, they would be. Yep.
Okay, and then the next one is, if you have a beneficiary identified for each asset, is a trust still good to have?
Yeah, I mean, that's a good question. What we're really addressing there is the probate question, right? Because you avoid probate if you have named beneficiaries. But again, I'd bring up, there are some exceptions to this rule, like real estate, you can't name a beneficiary on. So if your goal is to avoid all probate, then you really needed to create a trust to put your house in, because I can't own my house, Jamie Upson, and name my father as the beneficiary. I would need to create a trust, put the property into the trust, and name my father as the beneficiary. So yes, it's doable. You can accomplish a lot of things without creating the trust, but it's dependent upon your specific circumstances. So whoever wrote that in, I would ask you, do you own a home? And if you own a home, you're really not guaranteed to insulate yourself from from probate, and you may need what they call a realty trust to put your real estate into. And it's really just a revocable living trust. So it's pretty clean. It's not super crazy, and it really doesn't add a whole lot of complexity. Sometimes if you're trying to refinance a mortgage, it can add a little bit of complexity to it. Sometimes the mortgage companies require you to take the property out of the trust and then put it back in after you refinance. So there can be some quirky things about it, but all in all, it's pretty clean.
Jamie, the last question I have here is, do we have to see an attorney to establish a trust?
Yep, good question. So the answer is you don't have to, but if you ever go down the irrevocable trust route, I can't imagine not seeing an attorney. If you screw up and you aren't intimately familiar with how to structure trusts, then I would just warn. Those are just warning signs that you might make a mistake. And once you create that irrevocable trust, it's locked in. Revocable, they're a little bit more forgiving until you pass away, when they automatically become irrevocable. I know that there are certain softwares out there, like I think the Will Makers, which is offered by Nolo, N-O-L-O. I think they do revocable living trusts. Most times when you see the word living trust, they're talking about a revocable trust. Again, they use all these different verbiage or different words that just add a lot of confusion to this. But they many times will spit out a template trust that you could incorporate. So, and you're not seeing an attorney in that situation. So it's doable. I would just really caution you, especially with irrevocable trust, to not try to do that on your own without a qualified attorney. And that does bring up, the point that I should have brought up before, is that all of the information that I'm going over, I'm not an attorney, and we always want to work with the attorneys, not against them. So I always want our clients, once we've identified what it is that you're trying to accomplish, go see the attorney, go see the expert. They're going to be able to walk you through all of the details and the moving parts, like I will not be able to, because that's what they do for a living. So you'd be wise to go meet with that attorney and come back to me if you want with what they're suggesting. That's what I always tell our clients. Come back to me. Let me know what they're talking about. 9 out of 10 times I'm in agreement. 1 out of 10 times I will go back to the attorney and sort of push as to, well, why are you doing that? I've never seen that before. And again, not in a threatening way by any means. I'm just, maybe there's new rules that I'm not familiar with. I just want to find out. Or maybe they're taking advantage of our client, and I can't have that. I think by the silence, are we all set?
We're all set.
Okay, excellent. Thank you, everybody. We're at about an hour right now. So thank you, everybody. This will be recorded if anybody needed to review anything after, as well as there's going to be a white paper that's available on our website. I think it's under resources, I think we put it. There's a section where if you have any problems finding it, just shoot us an email. We can always send it to you. But there is a white paper that I wrote that goes into more detail. So once again, thanks everyone for joining us. Take care.